Any introductory remarks or association remarks before I start?
No, I'm good right now.
Okay, great. Well, welcome everybody. My name's Ed Estes, and I am your teacher for the day, or at least for the next 2 hours. We're going to go ahead and power on through. If you've ever attended one of my live sessions, I usually break after about an hour or so, but I'm seated. I got a full jug of water. I'm just going to kind of power on through. So we should get through this thing right around noon, maybe a little bit after. The other thing I like to do, I like to take questions at the end of the page. So we've got 10 pages, and of course the first page has got all the goodies in it, so does the third page. But if you can just use the chat. If you're not familiar with Zoom, of course I think most of us are because we've been living in Zoom for the last 10 months. But if you go down to the bottom of your screen with your cursor, you see a little chat box. You can click there. I think it's helpful to reply to everybody. You can make private communications, but if you reply to everybody, you know, everybody can see your question and I will respond to your question. That seems to work the best. Laura tells me we've got over 35 people. If we try to go with verbalizing questions, it gets a little chaotic. But at the end of the program, I have a Q&A, question and answer slide, and we'll just open up the mic then. If you want to just chat, we can do that. So I do have an appointment at 1 o'clock, but we should have plenty of time to get through this contract. So let's move on. We'll start with page 1. And what I've done is I've broken this down into sections. And I'm sure some of you have heard that they are going to be coming out with a new contract in December. So we're all looking forward to that, tongue in cheek. It's supposed to go to 16 pages. So I'll be talking with Laura and of course, John, your general counsel. John and I still don't know exactly how we're going to teach the darn thing, but we'll be presumably offering some additional classes, hopefully face-to-face, as we get closer to the release, which will be sometime in December, I believe. So at the top, date prepared. What is that for? Well, simply to give this contract a name. We are going to respond to this contract with a counteroffer or an addendum or an amendment. And it always says, this is an addendum, a counteroffer, an amendment to the purchase agreement dated. That's the date that goes there. Remember, all of your timeframes go from the date of signature or the date of acceptance. So the only reason we have a date on the first page is to give this contract a name. It doesn't have any other significance from there. So it's the date of signature, date of acceptance that we're going to run all the timeframes from. Very important as you put in the names of your buyers to list all of your buyers. Now, if you are planning on bringing another buyer in later, or maybe changing from one buyer to another, this contract does not allow assignability. So if you are going to be adding additional buyers, my recommendation is put in the buyers that you know under 1A, and then write in and or assignee or assignee, depending on how you like to call it. And then in paragraph 6, which we'll get to, you're going to write in paragraph 26 is deleted because it's paragraph 26 that prohibits the assignment. Now we're going to get through that as we go through this contract. So I'll bring it up again, but you do need to list if you're going to plan on assigning parties or bringing other parties in, because this contract does prohibit the assignment of the contract. Then under 1B, we want to list the address of the property. And you can use a common address, 123 Elm Street, City of Walnut, County of Los Angeles, and the zip code. And then it's also nice to put in the parcel number. Now, you don't have to put in the parcel number. To get the parcel number, you're going to have to go into Realist in your MLS, pull up the tax rolls. But the good thing about that is you will also see the name of the owner as far as the tax assessor is concerned. And the reason that's important is when you get your counteroffer or you get your acceptance, Those two people should line up. If they don't line up, you've got a problem. I once had an agent who worked for me, wrote an offer, got a counter offer back. The name on the counter offer did not match the tax records. He actually did a property profile. It seems that the tenants listed the property and were trying to sell it without the owner knowing about it. Now, we can laugh at that, but tenants don't know how title works, right? They don't understand escrows. So imagine how embarrassed that listing agent was. They took a listing on a property and they actually listed it with the tenant, okay? So again, if you are writing an offer on vacant land, now this is not the vacant land purchase agreement, but if you were writing an offer on vacant land, you probably don't have a street address. You may not even have a street. You can use the assessor parcel number to identify that property. So go by city, county, assessor parcel number. That is a sufficient description for the purposes of the offer. And then under C, we put in the purchase price. We did it both alphabetically and numerically. If you're doing it numerically in the shaded area on zip forms, it will automatically spell it out for you. If you're out in the field, if you're out in the field, you're going to have to use your best penmanship and spelling and actually write it out like you would a check, if anybody actually uses checks anymore, right? And then under D, close of escrow. So now you've got a choice. You either need to make a specific date or days after acceptance. Not both, because you'll never get it right, right? Because you have no idea when you'll get acceptance. So my recommendation is to check the second box and put in the days, 30 days, 45 days, 60 days, whatever you want your escrow period to be, all right? The reason I don't like the date, close of escrow shall occur on, and then write in February 28th or something. Well, if I'm doing February 28th, we're thinking what? Probably around a 45-day escrow or so, or maybe I do what? March 3rd, March 4th. A couple of problems with that. First of all, invariably, agents don't look at the calendar and you have your closing date on a Saturday, Sunday, or holiday. That can be a problem. But two, we don't know when this offer is going to be accepted. And if you're writing an offer on an REO, a property the lender has taken back from foreclosure and is now selling, real estate owned, it could take a couple of weeks to get final acceptance. Well, what happened to your 45-day escrow? Well, now it's what? 30 days. And that's not what the parties had intended, or at least not what your buyer intended. So most of our buyers are thinking of an escrow period of a certain number of days. I recommend you check the second box and put in days. But you've got a situation where you've got to close before the end of the year, or you're coming out of a 1031 tax deferred exchange or something like that, and you want to do a specific date, you can do a specific date. You could do either one. I just think that in practice, going days after acceptance will make life easier for you. Now, under agency, paragraph 2, you've already given the agency disclosure form. As a matter of fact, you should give that agency disclosure form to your buyer before you start showing the buyer property. Now, I know most of you give that AD form to your buyer right before you write the offer. Technically is still legal. As a matter of fact, it's the last part or point in time that you can give the disclosure form to your buyer and still be within the law. But here's the catcher. You cannot claim a buyer as your client until you first give the agency disclosure form. 2079 of the Civil Code is very clear. You cannot claim somebody as your client. You cannot claim an agency relationship unless you first give the agency disclosure. And I know you're taking buyers out, you're showing them properties, you're calling them your client. If you haven't given them the agency disclosure form, they're not your client under the law. Now, to create a client relationship, you need to have an agreement. It can be implied, it can be verbal, it can be in writing. you have to have an agreement. The AD form does not create an agency relationship. It merely discloses the difference between single and dual agency. The agency relationship is created by an agreement, either implied, verbal, or in writing. And there is the buyer representation agreement, which I've done many times for this association, where we go through how to get that agreement signed. And Laura tells me it is saved on the Tri-County's website. You merely have to scroll down and find it. Class is about an hour, hour and 15 minutes. So I encourage you to watch that. 2B, confirmation. So if you're writing this offer under buyer's brokerage firm, you want to list the name of your broker and you want to put your name where it says buyer's agent. You also want to put the listing brokerage company under seller's brokerage firm, and where it says seller's agent, the listing agent or the licensee who has the listing on the other side. And then you need to distinguish whether you're in single or dual agency. So if you're writing an offer on one of your company's listings, both sides are going to check the box, both buyer and seller. If you're writing an offer on somebody on a different company's listings, then under seller brokerage firm, you're going to check the seller for both the brokerage firm and the seller's agent. And for buyer's brokerage firm, you're going to check buyer and buyer's agent under buyer's agent. Okay. So just remember, if you're in dual agency, everything has to remain the same. Now, at the bottom there, we have C, potentially competing buyers and sellers. This contract requires you to use the PRBS form, possible representation of more than one buyer and seller. Please get that document signed with your buyer before you start showing them properties, with your seller before you take the listing. The purpose of that form is that if you find yourself in a situation where you have to go into dual agency, you've been showing buyers properties for the last 2 months, they finally agree to make an offer, and they're going to make it on one of your company's listings. Somebody else in the office has the listing, but it's in your brokerage company. You have to go into dual agency. Well, what do you do if your buyer says, well, I don't want to be a dual agent. I want you to represent just me. I read something on the internet that says dual agency is bad. Well, you've got a problem now, because arguably that buyer can walk away from you and write an offer on that listing with another agent from another company, and you're going to be hard pressed to be able to claim you're the procuring cause because you didn't get the PRBS signed. So please, you're going to have to get it signed anyway. Get the PRBS signed before you start showing the buyer property. And for you listing agents, get the PRBS signed when you take the listing. Think of it this way. The first form you need to have the buyer or the seller sign is the AD form, that agency disclosure. Second form you want them to sign is the PRBS form. Okay, get those two out of the way. Got to do it anyway. Get it out of the way. You don't have to worry about it. All right, so now we go into the finance terms. The first item is we have to put in our initial deposit. And the question always comes to me, particularly with new agents, how much deposit? Well, first of all, it doesn't matter. You don't even need a deposit legally. The deposit's not the consideration. This is a bilateral agreement. It's an exchange of promises. The purpose of the deposit is to show good faith. Now, having said that, the larger the deposit, the more good faith, right? Small claims court, for purposes of this agreement, is a maximum of $10,000. So I don't like to go over $10,000, because if you do, and there's a dispute between the buyer and the seller over the disposition of the deposit, they're going to have to hire a lawyer and go into superior court. If it's $10,000 or less, then it's going into small claims court. And if you want to know what small claims court looks like, turn on Judge Judy. That's pretty much small claims court, right? So I like to keep deposits 10,000 or less. If, however, you got a situation where the seller, and it's usually not the seller, it's usually the listing agent, where the listing agent or the seller's agent is demanding a larger deposit, then you may have to go over 10,000. But if you do that, I recommend that your buyer initial the arbitration clause. That way, if there's a dispute over the deposit, rather than going into superior court and pretty much having to hire an attorney, you can go into arbitration. Now, you can have an attorney in arbitration if you want to, but you don't have to. The nice thing about arbitration is their rules are much more relaxed. And my thinking is, if you've got a buyer and or seller who have a property that warrants or is sophisticated or has the means to bring in a $15,000, $20,000, $25,000 deposit, then those parties are probably sophisticated enough to go into arbitration and explain to the arbitrator why they are entitled to the deposit without an attorney. But of course, if they want an attorney, they can have one. All right, so that's my thinking of deposits. Now, the default language here says that the buyers kind of deliver those funds electronically into escrow. So there is no deposit check. Every now and then I hear of a dinosaur agent out there that wants a copy of the deposit check. It's been over 10 years since this contract has been changed. We don't use deposit checks anymore. That way you're not in receipt of trust funds. That way you're reducing the liability for yourself and your broker. So if you do have a dinosaur agent on the other side and asks for a copy of the deposit check, simply and nicely explain to them that we don't do deposit checks anymore. The contract was changed a decade ago. All right, make it nice and simple. Or if you do want to do the prehistoric way, if you check that box under 3A2, then the buyer is giving a check to you and you have to account for it as a trust fund. Likewise with B, I don't recommend an increase of deposit. It's going to create more headache for you, more liability for you. Not only that, most sellers think that that increase of deposit will be attributable to liquidated damages if the liquidated damages clause is initialed, but it won't be unless when the increase of deposit comes in, the agent doesn't give the buyer the RID or receipt for increase of deposit form. And typically when the increase of deposit comes in, the buyer delivers it straight to escrow and that RID form is not given. Therefore, the increase of deposit cannot be applicable to liquidated damages if the liquidated damages clause is initialed. So it's just going to cause you headache. So I recommend under 3A, encourage your buyer to come in with the most deposit, not to exceed $10,000, and leave 3B alone. If you have a buyer who's bringing in a cash offer, you will then check 3C, and you will attach proof of those funds. In other words, a copy of their bank statement showing they have the money. If you don't have that copy of the bank statement, then you have to check the box under 3C saying that the buyer will deliver those proof of funds within 3 days. All right. So this is a little bit different than what we're going to find at the top of the next page. If you've got an all cash offer, they need to provide proof of those funds. If they don't have it with them, then you need to check that box under 3C, and that gives the buyer 3 days to provide that verification. Okay? All days are calendar days, except for the amount of time the buyer has to deliver the deposit to escrow, and that will be 3 business days. Why 3 business days? Because escrow is not open on non-business days. So we can't very well have the buyer deliver the deposit to escrow in 3 calendar days because that third or fourth calendar day could be a Saturday, Sunday, or holiday. Okay? Under D, first loan, again, the contract language says it will be conventional financing with a fixed rate. You just need to put in the interest rate and the amount of points, not to exceed. If you have a government loan, you have boxes to check for that, as well as seller financing. If you're doing an adjustable rate loan, you have a box to check for that. All right. So please use paragraph D1 and D2 if you have a second loan, because you are explaining to the seller the kind of loan or financing you're getting, and that can help with the offer. Okay. If you leave it blank, then it is going to be a conventional loan with an unknown interest rate. All right. By putting in the interest rate, you give credibility to your offer. You also give credibility to the pre-qualification letter that hopefully you are accompanying this offer with. All right. I actually had an agent tell me in response to my question why they didn't fill out 3D, they said, well, we don't know what kind of loan we're going to get. To which I asked them, then how in the world did your lender write up this pre-qualification letter? So again, it gives authority, it gives credibility to your offer. The more credibility you have, the better chance of the seller accepting your offer. So again, it's all about appearances, and you want your offer to look strong. Some of you may remember the dark times in real estate, 2009, 2010. We had a lot of short sales. We had a lot of lenders ignoring offers on foreclosures and things like that. And once asked one of those super duper listing agents who had like 30, 40 listings, all REOs, or foreclosures. What is the biggest reason they don't respond to offers? And they say the offers are so badly written, we don't even know what they say. So again, you need to give credibility with your offer. If your offer doesn't look credible, it's not going to be well received. Then paragraph D3, if you do have a government loan or you're asking for a government loan, FHA or VA, remember you are going to, within 17 days, have to give the written request to the seller on any repairs that need to be done or any costs, in the case of VA, that seller's going to be asked to pay for. If you're new to the business or not familiar with FHA or VA, I strongly encourage you to sit down with an FVA or FHA or VA lender and have them walk you through the process. It can be a little tricky. It's not overly complicated, but it can be a little tricky. So you want to understand how government loans work if that's going to be an area of your practice. Under E, any additional financing terms, this is a great place if you want the seller to pay for any closing costs. This is a good place to put it. This is where agents like to look for it. Then finally, or second to finally, F is the balance of the down payment, and then the purchase price goes into G. Now, if you're using zip forms, these columns will automatically add up for you. 3A, 3B, 3D, 1 and 2. So you just put those numbers in there, it'll automatically add up because it knows what the purchase price is from the top of the offer. If you're out in the field, you're going to have to add it up yourself. So for those of you who are new, I apologize for my veterans, but for those of you who are new, let me show you the way to make sure this adds up. Okay, first of all, under 3A, you know what your deposit is. So you want to write in your deposit in 3A. Then, remember I said don't do 3B, right? We don't want to increase the deposit, right? Under D1, you know what your loan amount is because it's typically a percentage of the price. 80%, 10%, 80%, 90%, 25%, whatever the loan is. Let's say it's an 80% loan, okay? So you just take 80% of your purchase price and you put that down in D1. Okay, so what you do then is purchase price minus 3A minus D equals F. Okay, so it's purchase price minus A minus D equals F. And then if you take A plus D plus F, you will equal G. But you already know what G is because G is the purchase price, right? So we know what the purchase price is. So G minus A minus D equals F. Just remember that. And that way, when you write up your offer, go back over, take A plus D plus F, and make sure it equals G. If your column here does not add up, you're out in the field, so you don't have zip forms to use, you're writing this on the hood of your car, and they don't add up, you have no credibility with the listing agent, no credibility with the seller. You can't even add, right? A third grader can add this column. So please go back and check your math because this is such an easy area to make a mistake. And the way you get your columns in there again, okay, is you take G minus A minus D, and that will equal F. So this is the end of the first page. Let me go into our chat room here and see if we have any chats. And I don't see any chats out there.
呀，我弄不进去了，弄不进去。
Yeah, you have a question? No? Okay, so let's go to page 2. And if I get to the end of page 2 and you have questions about page 1, we go
累
back.
死我了！
Question?
他妈的，这怎么办呢？
Okay, just remember if you could mute your microphones.
I muted
because
everybody.
Yes, Laura.
I muted everybody.
Oh, you muted everybody. Okay, so no questions in the chat room, right? Okay, let's go into page 2. So at the top of page 2, verification of down payment and closing costs. So this says that within 3 days, 3 calendar days, the buyer will provide to the seller. Oh, we got a chat. Let me see if I can take this chat real quick. What do we need to write down when we want to add an additional buyer on the line? Okay, if you know the buyer's name, you write down the name of the additional buyer. They're on 1A. If you don't know the additional buyer's name, or for some reason you don't want to disclose the name of the additional buyer, then you would just write assignee, okay, or assignee. So it would be Bob Buyer and or assignee, ASSIGNEE, just right in there. And then when we get to paragraph 6, I'll tell you where to delete paragraph 26, all right? Okay, let's see, got one more chat, looks like. On 2B, is the brokerage license number or the sales license number? Very good question, both. So when we go down here to 2B, next to seller brokerage firm, you want to write in the license number of your brokerage firm, all right? Now, that could be the individual license of your broker. If your company is incorporated, then you have a corporate broker's license to put in the first one. On the second line, if you are the listing agent, it would be your license number. If you are writing this offer, you would put your brokerage license number next to buyer's brokerage firm. You would put the buyer agent, your license number in that last line. Now, It's real easy. Of course, you know your license number. You certainly know your broker's license number. They should have given it to you. But if they haven't, just go to the DRE website, www.dre.ca.gov, type in the other agent's name. Of course, you know what their license number is because they have to put it on all their advertisements, right? So it's in the MLS. And then the broker's number should also be in the MLS. If for some reason it's not, somehow it got through, just type in the listing agent's license number. And when you pull up their license on the DRE website, you'll see their
跟我
broker's
这样的，
license there as well. All right. So again, it's a public document. All right. So I think we got through all of our questions. So now let's move on to page 2. All right. So back to H. Here, okay, within 3 days, we are going to deliver to the seller proof that the buyer has the down payment and closing costs. Now that can be a bank statement. If it's a bank statement, it should cover the last 3 or 4 months to show the money is really there. If money just appeared in the last 2 weeks, we know it's not really the buyer's money. It's probably a silent loan from a friend or family member of the buyer. Or it could be a letter from the bank manager where the buyer has their bank account saying they have the funds. Or you can attach it with the offer to give your offer more credibility. And then you would check that box where it says verification attached. It's just the opposite with the all cash offer. Remember on the first page, I said with an all cash offer, you have to supply proof of funds with the offer unless you check the box. Here, you don't have to supply proof of funds unless you check the box. So it's just the opposite. Why CAR did it that way, only CAR knows. CAR does some strange things sometimes. Okay, under I, appraisal contingency. This offer is contingent on an appraisal unless you check the box. Even if it's an all cash offer, they still have an appraisal contingency. So if you're representing the seller and you have an all cash offer, when it comes time for that buyer to release contingencies, remember in that contingency removal form, they can release all the contingencies.
你给我录不见了，弟弟。
They can remove all contingencies except for, or they can release contingencies one at a time. Make sure that all contingencies are removed, including the appraisal contingency, right? Going down to J, loan terms. Within 3 days, buyer is going to deliver that pre-qualification or pre-approval letter, unless you check the box under J1, which means the letter's attached. Again, it's just the opposite is what we had with the all cash offer paragraph on the first page. J2, this loan is contingency. The buyer's going to act in good faith to get the loan that they said they were going to get back on page 1. So if you have a buyer who's going FHA or VA, you need to disclose that back on page 1, okay? Back here under 3D1, you need to state FHA or VA if you're going with an FHA or VA offer. Because the language here without that box checked means you're going with conventional financing. And it would be a material misrepresentation to cause a seller to believe that you are coming in with a conventional loan when in fact you are coming in with an FHA or VA loan. And when I say substantial or material misrepresentation, I'm talking fraud, okay? You do not want to be a party to fraud. All right, under J3, loan contingency removal. We have 21 days for the buyer to remove their loan contingency, which means the buyer's having a problem with their loan, or they can't seem to get the loan they're trying to get, they have 21 days to back out, all right? Now, if that's not enough time, you can put a larger number in those parentheses. If your buyer is pre-approved, ready to go, and no questions on getting it, if you want to shorten that time frame, you can do that as well. Okay. Just remember, if you're shortening the time frames, you're creating greater risk for your buyer. Right? Now, under J4, no loan contingency. That means the buyer's going to buy the property even if they can't get a loan. Well, how are they going to do that? They're going to have to pay cash. Well, what if they don't have cash? Then they could be in breach of the contract. So you do not check J4 unless the buyer is prepared to pay cash if for some reason they can't get a loan. And I've seen some very strong buyers that had a screwy lender that wasn't able to get a loan and had to switch lenders, had problems with their loan. So again, unless they're very prepared to pay cash, I don't recommend you checking J4. Now, J5, lender limits on buyer credits. This is a lender thing. And in that regard, it's kind of a disclosure thing. So here's the deal. We know that 20% down is the sweet spot for a loan. Lenders like 20% down. Actually, they like more than 20% down. But if it's less than 20% down, then you're going to need some kind of a guarantee or some kind of insurance, either PMI, MMI, whatever. But you're going to need something to protect that lender. So let's say you have a 20% down buyer. Lender's happy because at 20% down, no PMI, don't have to worry about FHA, VA, you're good, right? 20% down. But you ask the seller to pay buyer's closing costs of $8,000. I'm just saying that. And let's say buyer's closing costs are only $6,000. Well, what happens to that $2,000? Well, essentially, it's going back to the buyer. What happened to their 20% down? What's not 20% down anymore? It's 19.98% down or whatever. And that means less than a 20% down for the lender, and that follows up the loan because the lender wants that 20% down to be the buyer's money, not a credit back from the seller. So what this paragraph says is, if there's an excessive amount of credit given to the buyer that causes the down payment to be less than 20%, then that excess will be given back to the seller. There will be no adjustment on the sales price. Again, this is a lender thing. We have no control over it. It's a lender thing. So if you want more information on this or you want to argue it, argue with your lender. You know, this is the game we have to play. Okay. K, buyer stated financing. Remember going back, I said how important it is that you are truthful on whether it's a conventional or a government loan. K is saying the seller is relying on the representation of the type of financing specified in the first page. And if it's not accurate, you could be guilty of fraud. You do not want to go there. So please don't say you're going conventional if you're going FHA or VA. I get a response back, but if I say FHA, VA, the seller might not accept my offer. Exactly. That makes it a material fact. It's like the seller saying to the agent, well, if I tell the buyer about the leak in my roof, the buyer may not buy the property. Exactly. It's a material fact. So don't misrepresent material facts. Okay, so paragraph 4, if you have a buyer who's making this offer contingent on selling their old property, then you check the box under 4B and attach the COP form. The COP form has been expanded. It's now a 2-page form. It tells the seller the property that the buyer needs to sell, whether it's listed, if it's in escrow, information about the property, the escrow, It also states to the seller whether the seller can cancel the first offer if they get a second offer and the procedure for doing that. So please, your homework for today is go into Zip Forms, pull up the new COP form. It's now 2 pages from 1 page, and review it. Paragraph 5. If we have additional stuff, okay, rather than making this 10-page form a 40-page form, right? We have a number of addenda and advisories that can be attached. So that can be checked here. If you need more room to write more terms other than what's provided in paragraph 6, they're up in 5A on the right-hand side. You can attach the CAR addendum form. It's a 1-page form with pretty much nothing but lines. However, the reason you only have 4 lines in paragraph 6 is we want to limit, as much as we can, your ability to change this contract. This contract should be sufficient by just filling in the blanks for most of your transactions, all right? If you are substantially modifying this, you could be walking into the unlicensed practice of law. So you want to be very careful and very clear on what you're putting in other terms. Now, remember earlier I said, if you have a buyer that might want to add another buyer or assign their rights, well, in paragraph 6, you would write in paragraph 26 is deleted because it's paragraph 26 that prohibits assignment. That's all you have to write. You see, we don't want to draw lines through paragraphs. We don't want to cross things out. If you want to get rid of something in this offer that you are writing, then in paragraph 6, you just write down delete and that paragraph that you're deleting. If you are the seller or the seller's agent and you want to delete something in this paragraph, then in the counter offer, you simply delete whatever it is you want, okay? So again, if you're changing this document as the buyer's agent, you add or delete in paragraph 6. If you don't have enough room, then you add that CAR addendum up there under 5A on the right-hand side. If you are representing the seller and you want to change a term in this contract, you do it in the counteroffer. And you don't have enough room in the counteroffer, you add the CAR addendum to your counteroffer. That's going to make your contract much more clear. Now, paragraph 7. Our first paragraph, A1, is who's going to pay for a natural hazard zone disclosure report. Now, this is not a disclosures class. So for the purposes of this class, you want to make sure you have an NHD or natural hazard zone disclosure report on all of your transactions. Most sellers will pay for that without question, including lenders, including executors in probate. It's an inexpensive charge. What? Little over $100 to get the full report with local mapping. You know who these companies are because they come into your office with tablets, with pens, donuts, cookies, right? Talk to your broker or your manager for your office's preferred list of NHD companies. F2, excuse me, I'm sorry, 7A2. This is where, and A3, this is where you can ask the seller to pay for any additional reports. Now, question often comes up. Should the buyer or the seller pay? The seller should pay. Here's my thinking. If the buyer is willing to pay for something, leave it blank. Because the buyer can always pay for something, right? Seller doesn't care whether it gets paid for or not. Seller doesn't care if it gets done or not. They're selling the property. Seller could care less. It's a buyer who wants the seller to do certain things, like sell the property to them at a certain price. So if you want the seller to pay for a report, check the seller box. The reason I don't want you to check buyer is because the lender is going to see this contract. And if you check the box buyer, the lender may put that item as a loan condition. Now, the seller doesn't care whether the buyer pays for it or does it or not, but now the lender is requiring it for the loan. So the buyer is on the hook paying for it. And sometimes the buyer doesn't have nearly as much money at the close of escrow as they thought they were going to have. All right. Now, termite is often brought up under 7A2. This is what you should be writing. Under 7A2, check the box, seller to pay for the following report. Termite, or if you want to be technical, structural wood pest destroying organism, because that's what it actually is. But you can write termite. And then on the second line, prepared by the termite company that you'd like to use. And there are good termite companies and there are not good termite companies. So your office should have a list of preferred termite companies, right? Do not try to write in here seller to pay for repairs. Two reasons. One, you don't know what those repairs are. You don't want to commit the seller to paying for something and they have no idea what it's going to cost. Right? Second reason, you may get sued by the seller if they can't afford to pay for it. Now, most of us are familiar with local treating that can cost up to $1,000. If it has to be tented, $4,000 to $6,000, depending on the size of the house. I've actually seen two termite reports. One was for $38,000. The other was for $42,000, where subterranean termites had gone in and damaged load-bearing parts of the house. So I know you want the seller to pay for the work. Now, the work comes in two types, Section 1 and Section 2. Section 1 means there are bugs eating the house. Section 2 is a condition like dirt touching the house, the wood members of the house, that can lead to subterranean termite infestation. Subterranean termites have to stay in the soil. They can't fly in the air like drywood termites do. Anyway, Section 2 is a repair item, maintenance. Section 1 is you have bugs eating the house. That's the most important. My recommendation is we can go two ways. If you want the seller to pay for the report, check that box. Then, when the report comes back, do a request for repairs. In the request for repairs, ask for the termite to do the termite repair, the Section 1 work. Now, of course, the problem there is, A, the seller may not want to pay for it, and they may reject your request for repairs. But here's your negotiating point. The seller now has a termite report, and they're going to have to disclose it to the next buyer, because if they will not make the repair, since your buyer's lender will not do the loan because they now know the property has termite because it asked for a copy of the report because it was in the contract, you're going to cancel. Seller's going to go back on the market, and seller's going to have to make this disclosure to the next buyer. And that buyer's going to want the seller to do the repairs. So the seller's not going to get out of doing the repairs. They might as well do it now. Now, if you don't want to do that, I've got another one for you. Leave it blank. There are termite companies that will do termite inspections for free. You all know who they are. Your buyer can ask a termite company to come out and do the inspection during their first 17 days. If that termite company finds infestation, since the buyer has not put the termite inspection in this offer, the lender does not know that there was a termite report done on this property. The lender does not know about the termite infestation. Therefore, the lender is not going to require that the termite work be done. So if the buyer wants to buy the property with termites, they can. But the buyer can still request that the seller do the repairs. And the seller knows that if the seller doesn't do the repairs, it's more than likely the buyer won't buy the property, which means the seller has to go back on the market. And the next buyer has to be disclosed of the termite infestation. And that buyer is going to require that the repairs be done. So the buyer is in a much stronger negotiating position. So anyway, that's my thoughts on termites. It's just that you're going to get yourself in trouble if under FA2, you write in seller to do all termite repairs or section 1 work. You're asking for trouble. You're asking for a lawsuit from the seller. So I would say, don't go there. Okay, now we've effectively covered all of this. We still have paragraph 7B, but it actually carries over to the next page. So I'm going to go ahead and answer questions in the chat now, if I can get over to it. Okay, so the first question here is, can you explain J2? Okay, so we'll, oops, let's go back. Okay, what J2 says is that this offer is contingent on the buyer getting a loan, okay? The buyer is going to act in good faith and work hard, diligently to get the loan, okay? So if the buyer cancels because they can't get the loan, it's because they couldn't get the loan despite having worked hard to get the loan. So if the reason the buyer didn't get the loan is because they weren't providing the loan application or their tax returns or their pay stubs to the lender, then the buyer would be acting in bad faith and the buyer has not met the requirements of the loan contingency. So basically the buyer has to act diligently in good faith, properly to try to get their loan. All right. Okay, so let's go back up into my chat. Okay, what if another buyer is a spouse or relative or something like that who is not taking over the contract, just being added as an additional buyer? Can they be added to the contract later during the transaction, and how? Yes, they can. Since the original buyer is still buying the property, I don't think that would violate the prohibition of assignment because the original buyer is still buying. If it's a spouse, it's not a problem because California is a community property state. So what is done by one spouse is done by the other spouse. But if you do have other relatives coming on or might be coming on, I think it's a good idea to make mention of that in the buyer line. Is this class recorded? Yes. Will you be able to review it later on? Yes, you will. As a matter of fact, Laura tells me that the last 4 or 5 of these lectures are recorded and on the website. So, you know, you're getting me live and you can ask me questions but pretty much all of my classes have been recorded. So you're welcome to go in there and listen to them. Must the reasons for backing out on a contingency topic be proven directly for each contingency issue being challenged? Not under this contract, Richard. You don't need to give a reason under this contract. However, I have seen a preview of the new contract coming out in December, the one that's going to 16 pages. And it appears that that contract is going to ask for a reason. My recommendation is you don't give a reason. Because if you give a reason, the seller's going to try to fix it, and that gets kind of messy. So if after the buyer inspects the property, they find things with the property they're just not comfortable with, and they just don't want to buy the house, even if they get cold feet, they can probably walk away. However, if the reason the buyer is not buying this house is because they're also in escrow on another house. In other words, the buyer made offers on 2 or 3 houses, got acceptances on 2 or 3 houses, and now is deciding which house they're going to buy, and they never intended to buy all 3 or all 2 houses. Is that bad faith? And the answer is yes, it is. Could that get them into trouble? Yes, it could. The reason for the contingency is because you were not able to buy this house because of this house, not you didn't want to buy this house because you decided to buy the other house. All right. All right. So let's go down to 7B, government requirements and retrofit. So first of all houses, unless they're exempt, must have a smoke alarm, carbon monoxide device, and water heater bracing. If your house doesn't have that, I understand you are liable for a $100 fine. All houses must have those. Doesn't matter whether you're selling or not. All houses must have those. Whether a tenant's living in it, you're living in it. Now, if it's vacant, you probably don't have to have one. But if it's occupied, you have to have one. All right. Question is, if this house doesn't have those, who's going to pay for putting that stuff in? So I always put the seller. Okay. House is supposed to have it. Seller's in violation of law if the house doesn't have those items. So seller should pay for them. When I say exempt, if you got one of those tankless water heaters, it's already mounted to the wall, so you don't have to worry about water heater bracing. If you have a house that does not have a garage, has all electric appliances and no fireplace, then you're exempt from a carbon monoxide device because there's no fuel being burned in the house. But other than that, you must have those 3 items. Now, going to the top of page 3. Number 2, if there is a inspection required by the city for this house. A lot of your cities do have required inspections of property in escrow. And they charge for that. They might charge $75. They might charge $150. I don't know. But if you're in one of those cities, who's going to pay for that? Seller or buyer? I always put seller. And then if a property needs a retrofit, and the most common retrofit is low flow devices, plumbing, shower heads, faucets, things like that, toilets, okay? Who's going to pay for that? Now, if the property was built since 1994, the building code requires those properties to already have low flow plumbing devices. So you shouldn't have to worry about it unless the seller's been modifying the property. But if the property is older than 1994, was built before 1994, it could be an issue, okay? So again, this is a negotiating tool or negotiating point between buyer and seller, but I always check seller. Under C, escrow and title. Here in Southern California, buyer and seller typically split the cost of escrow. And under C2, seller typically pays for title insurance. So under C1, I would check buyer, seller, check them both. And then in the blank next to that, I say each to pay their own. I say each to pay their own because the buyer is also paying for the loan escrow. See, in a transaction, we actually have two escrows, right? We have the sale escrow between the seller and the buyer, but we also have the loan escrow between the borrower and the lender. Each to pay their own, 50-50. We don't want people think that the seller is going to pay half of the buyer's loan escrow, right? And then who the escrow holder is going to be. And then under C2, who the title company is going to be, right? Now, you're going to be calling that other agent who has the listing before you write the offer to, one, is the property still available? Two, do you have any offers on the property? Three, I want to let you know we're writing an offer. So they don't accept somebody else's offer in the meantime, right? So you're going to be calling that other agent. It's a great time to say, hey, agent, do you have a particular title company, escrow company, home warranty company, whoever, that you really like? And maybe they do. And if you don't have a problem with those companies, you might want to talk to your buyer and say, hey, buyer, this other agent really likes ABC Title and XYZ Escrow. We put those companies in there, we might make that agent happy. If we make the agent happy, maybe they'll fight a little harder for our offer. It makes your offer look better to the agent, right? And let's face it, yeah, sellers kill offers, but the seller's agent also kills offers, right? So I try to make that seller's agent as happy as I can when I write my offer, assuming you don't have a problem with their escrow or title company. I will say this, if it's a broker-owned escrow company, they cannot do the qualified substitute under FIRPTA. Okay. So again, if you're using the qualified substitute under FIRPTA, can't do that with a broker-owned escrow. Just a funny little quirk in federal law. So again, make sure the escrow company or the title company is someone that you're comfortable with, because you don't want to steer your buyer into a third-party provider if they won't do a good job. Now let's go down to D. I don't like seller's choice. Just to let you know that. I don't like seller's choice simply because I like to have the contract complete when we get acceptance. I don't like loose ends. So seller's choice does not make me happy. All right, under D, seller typically pays the county transfer tax or fee. That's that $1.10 per thousand. Some cities do have local transfer taxes. Since I don't know which one they are, I always check seller. If you do want to know what cities have inspections at close of escrow or what cities charge transfer fees, okay, talk to your government affairs rep. Laura can tell you who he or she is. Number three, if there is a homeowner association fee, you can have the seller pay for that. If your homeowner association prepares additional documents beyond what's required in Civil Code 4525, under paragraph 5, you can ask the seller to pay for that. And if you have a private transfer fee in this development, you can ask the seller to pay for that. Again, for 1 through 7, I typically just check seller. It's seller's property. I like them to pay the fees that relate to the transfer of the property. Now, going down to 8 and 9, if you want seller to pay for something else, you can put that in there. I don't recommend closing costs there or credits there. I like it better to be back on page 1 at the bottom where we talked about it earlier. I've actually had agents say the reason some people want to put credits or loan costs under D8 and 9 is to try to hide it. Of course, my response to that is, do you only read the first page of the contract? I was being a little surly that day. But again, when you write your offer, I think you should write the offer in a way that makes it the most understandable. We want to have a good relationship with the other agent. Trying to trick them, it's only going to come back and haunt you. And then under D10, if your seller, or if your buyer would like the seller to pay for a home warranty plan, you can check the box for seller to pay for that. If the seller or your buyer does not want to have the seller pay for that, you check the box below that where the seller or the buyer is waiving the purchase of a home warranty. Again, I don't want to obligate the buyer to pay for a home warranty plan because it may show up in a loan condition. But if the buyer wants to pay for it, even after declining, they still can. Notice at the bottom there, it says buyer waives the purchase. Nothing in this paragraph precludes the buyer from purchasing one if they want to, all right? Now, when would you most likely see a home warranty plan? If you have an older home, okay? Now, if it's a relatively new home in Chino Hills, okay, or Diamond Bar, probably not necessary. But what if it's an old home, say an 80, 90-year-old home in Pomona or Covina with original appliances? Your buyer may be a little reluctant to buy that house because of those old appliances. Well, ask the seller to purchase a home warranty plan. And then for a what, maybe a $60 service call, if the buyer does have appliance go out on them, they will come out and either repair it or replace it. So it's just a nice little insurance policy for appliances. And you can customize it for air conditioning, pool, spa. Again, those home warranty reps, they're the ones that will come out, bring you donuts, cookies, tablets, pens. Your office probably has brochures all over the place. Okay? Paragraph 8, real versus personal property. Now, I have a little bit of a warning there under 8A. Under 8A, it says, things included or excluded in the MLS flyers or marketing materials are not included unless specified here. Don't believe it. Small claims court judges, because that's where you're probably going to find yourself. If you don't specify the spa being included and the seller removes the spa and that buyer sues you and the seller and the other agent for not having a spa, if the flyer or the MLS mentioned the spa being included, then that small claims court judge is probably going to rule it's a misrepresentation and they are going to hold against you. The rule is you always lose in court if you get sued by a buyer unless you make it abundantly clear what the buyer is getting and what they're not getting. So, having said that, under 8B3, list all the items that are being included, like the spa, the swing set, the gazebo, barbecue console, you know, those things they sell at the Pomona Fair, the Sears storage shed in the backyard. If you need more room, attach that CAR addendum. If the seller's going to be removing anything, under 8C, okay, a chandelier, refrigerator, that looks to be built in, anything like that. The seller's removing things that look like they're part of the property, specified in C. If the seller's including things, or if the buyer wants to include things. So you do need to read the MLS description. If you see verbiage in there where the seller is throwing stuff in or including things, or the seller's not including things, you need to repeat that here in 8B and C, all right? Also, under 8B5, leased and liened items, if you've got solar panels, okay, there's probably a loan on it, or it's probably leased. If you have a property that has a PACE loan, okay, then those things need to be addressed. The seller is conveying the property and everything attached to the property. If you go out on a listing appointment or you're writing an offer and you see solar panels, you need to have a conversation with that agent and ask him what is the status of those panels, because more than likely the buyer is expecting to get them. And if there's a lien on them, then that could be a problem. Now, there on number 9 at the bottom, the land contract language says that the buyer intends to live in the property. If not, you check the box. If it is seller occupied, the language says the possession will be delivered to the buyer at 6 p.m. on the date of close of escrow. If you want to extend that period of time or shorten that period of time, you can do so. It is never a good idea to let the buyer move in early or even store their stuff in the property early, even though there are CAR forms that allow for that. Also, it's never a good idea to let the seller stay in the property late, even though there are CAR forms to do that as well. You want the property turned over to the buyer at 6 p.m. or sooner on the date of close of escrow, all right? Let's go up and see if we've got any. Got one item in the chat. Let's see, what is a private transfer fee? Private transfer fee is typically found in developments in outlying areas, Inland Empire, go out east of Redlands. What has happened is the developer got challenged for their development, and perhaps they made a deal with an environmental group. Let's pick on the Sierra Club. And in order to get them to drop their opposition to their development, they've agreed that for a period of time, any transfers of property within that development, let's say a $200 fee will be paid to this environmental group, or put into a fund or mitigation fund or something like that. That is a private transfer fee. It's not Mello-Roos, okay? Mello-Roos is actually a taxing district set up by the government to pay for infrastructures. It's similar, but typically a transfer fee is a one-time fee paid at close of escrow, whereas a Mello-Roos is something that shows up on the tax bill, okay, that will go out for maybe 20 or 30 years, okay? Must reasons for backing out on a contingency be proven? We already talked about that one. What if the seller is stating that buyer possession is to be close of escrow plus 3 days? You can put that in the contract. We're actually going to talk about that on the next page. You just need to make sure you have your rental agreement established for those 3 days that the seller is going to be in the property. So I'll talk about that in about a minute. Let's see, don't see anything else coming in. So we're going to go to that next page. Page 4. Okay, so if the seller is remaining in possession after close of escrow, the issue is, are they going to be in possession for more or less than 30 days? If it's less than 30 days, you check the first box, which is the SIP form, seller in possession. If it's more than 30 days, you check the second box, and that is the RLAS, residential lease after sale. Now, I said I would never let a seller stay in a property after close of escrow. That's not quite true. There's one exception I make, and it's for sellers who are in their 80s. Because if you have a seller in their 80s or 90s, the most important thing to them is what we call convenience. Moving is traumatic. It is stressful. And older people don't like stress. And I have found that in a situation where I have an 85-year-old couple, if I'm willing to let them stay in the property for 3 or 4 days after escrow closes to give them a little bit of more time to move out, I may get a much lower may be able to buy that property for a much lower price. Why? Because when you're in your 80s, it's not about the money anymore. You're in your 80s. You'll never spend it all, right? You're in your 80s. What's most important? Convenience, right? And I'm not worried about a seller in their 80s trashing the house. Would I do it with a couple in their 30s or 40s? Heck no. I want them out at 6 p.m. at close of escrow, okay? So that's how I think about it. Why do we have two different forms, the SAP and the RLAS? Well, if you have a seller staying in the property for longer than 30 days, you now have a full-blown rental agreement, and you need to address issues such as rent and security deposits and perhaps notices, things of that nature. So the RLAS is a full-blown lease agreement. The SIP is a rental agreement as well, but it's a much more simplified version. All right, so that's the difference between those two. Now, if the property is tenant occupied, paragraph D says the property will be vacant for 5 days prior to close of escrow, because that is the period of time the buyer has to do their final walkthrough, 5 days. You want the buyer to do their final walkthrough with the tenant out of the property. It's a good way to assure the buyer that they're not going to close escrow with a tenant occupied property when they're trying to move into it. Now, if you have a tenant occupied property and the tenant's in there under a lease, they have the right to stay in there till the end of the lease. So there may be some negotiating with the seller, and the seller may have to negotiate with the tenant to get the tenant out early, which may be a cash for keys type thing. If the tenant is in a month-to-month situation, if the buyer is intending to live in the property and it is a single dwelling unit, a house, a condo, not a 2-on-1, not a duplex, you only have to give the tenant a 30-day notice, even if the tenant has been in the property for over a year. The 60-day notice requirement does not apply. Why? Well, the thinking is under the code, once you put that for sale sign on that property, the tenant knows that it's time to move out, right? Their time is coming. So you only have to give a 30-day notice. However, still going to take you at least 60 days, more or less, to close escrow, because most sellers don't want to give notice to their buyer, which means most sellers don't want to give notice to their tenant until after the buyer has given or released their contingencies. So you have a 21-day contingency for loan. You have a 17-day contingency for inspection. You have a 30-day notice. So 17 plus 30 is 47, plus 5 days to do the walkthrough is 52. Which means is 52, yes. If you're using the loan contingency, you have 30 days plus 21 equals 51 plus 5 equals 56. So you've got at least 52 to 56 days to make this thing work. So What I would do back on other terms, paragraph 6, I would write in there, seller to give 30-day notice to tenant immediately upon buyer releasing, immediately upon, buyer releasing contingencies, close of escrow to be 30 days or sooner. Because you want to make it clear to the seller that the seller needs to give the notice to the tenant, and it's the seller's responsibility to get that tenant out of the property 5 days prior to closing. Okay, I have too many situations where we come up to close, the tenant's in the property, and you look at the agent and say, hey, your seller hasn't gotten the tenant out. What's going on? I don't know. You look at the seller and say, why is the tenant? Oh, I don't know. Well, seller is in breach of the contract, which means the buyer's going to have to extend their loan. That's going to cost the buyer money. The seller's going to be responsible for that. So it's very important that the seller and the listing agent understand that it's the seller's responsibility to get that tenant out of the property. Okay. And then E and F basically says all warranties, keys, codes, all those things we need, garage door openers, all that stuff is going to be transferred over to the buyer at close of escrow. Okay. The rest of page 4, paragraph 10, this is just a reminder of your statutory duties. I call your attention to 10A4. Nobody knows about 10A4, and now you're going to know something your broker or manager probably doesn't know. It's 10A4 that says if the seller has to complete a transfer disclosure statement, they must also complete an SPQ, seller property questionnaire. If you have a seller who's exempt, who does not have to complete a transfer disclosure statement, so that is a lender foreclosure and probates primarily, court-ordered sales, they have to do an ESD, an exempt seller disclosure. All right, so that's found in 10A4. Now, my experience is lenders will not do an ESD. So if you are representing a lender on a foreclosure, okay, the lender took back the property, it's now an REO or real estate owned, you may want to talk to your seller, the lender, about countering out 10A4. And you can, because the SPQ and the ESD, these are forms required by contract, not the law. The TDS is required by the law, Civil Code 1102, but the SPQ and the ESD are not. So if you have a, let's say an investor seller, they've got to do a TDS, but they refuse to do an SPQ, can they counter it out? Yes, they can. If you have a lender who is exempt, does not have to do a TDS, and they don't want to do an ESD, which most lenders don't, you can counter it out. All right. Contract also goes into the FIRPTA requirement, Foreign Investment, Real Property Tax Act. Also makes the Megan's Law disclosure of sexual predators. Also makes the gas and hazardous liquid transmission lines disclosures, and states that the seller has 7 days to disclose to the buyer if the property is in a condominium or planned development. And you would normally do that on an SPQ or an ESD. All right. I believe that finishes up page 4. Let's go in and see what I have in my chats. Okay, could you go over removing of contingencies? Okay, so I think what Valley is asking about is dealing with a property that has a tenant in the property. You want that tenant out of the property 5 days prior to close of escrow, because the buyer doesn't want to have to deal with the tenant, right? So you make your offer, and then in other terms, that's paragraph 6. You want to write in paragraph 6, seller to give 30-day notice to tenant immediately upon removal of buyer's contingencies. So that'll be sometime between the 17th and the 21st day. See, seller doesn't want to kick their tenant out unless they know the buyer's going to buy the property. But once the buyer removes their contingencies, they can't cancel anymore without being in breach. So the buyer has really gone hard in terms of going through with his contract. So seller to give 30-day notice to tenant immediately upon buyer removing contingencies. Escrow to close within 60 days or sooner. Because depending on whether you're using a 17 or a 21-day contingency, you're going to have anywhere from 52 to 56 days when you add the contingency period to the 30-day notice period. The key is you want that tenant out, and you want to make it clear to both the agent and the seller that it's their responsibility to get rid of that tenant. Okay, so from them out, question, and it's a direct message, but I still need to read it. For sales purchases on homes with tenants, after including the number of days notice and contingency of tenant moving out, does CA's AB 3088 Tenant Relief Act protect tenants from moving out after the purchase? If so, okay, no, as long as it's after, no. It might have prior to August or September 1. After September 1, I don't believe so. But the Tenant Relief Act, or most of the Tenant Relief Act, goes away at the end of this month unless it's extended. But within the Tenant Relief Act, this is what you need to know about the Tenant Relief Act. You cannot evict a tenant for non-payment of rent. All you can do is get a judgment against them and then garnish their wages or seize their bank accounts or get a collection agency. You cannot evict a tenant for non-payment of rent under the Tenant Relief Act. That's the first thing you need to know. The second thing you need to know, to evict a tenant, you can evict a tenant for, I think it's 3 reasons. 1, the tenant is violating the lease in terms of the occupancy. In other words, they're damaging the property. They're engaging in an illegal activity. That's 1. 2, you want to move in a family member like yourself. Okay. 3, you're going out of the business. Selling your property is going out of the business. So the Tenant Relief Act provides for the removal of a tenant if you're going out of the business. Selling your property is going out of the business. You're no longer in the landlord-tenant business on this property because you've sold it. So you are in compliance with the Tenant Relief Act. The problem is the courts are all messed up because of COVID and our stay-at-home orders, right? So getting through the court system is a little dicey. I strongly recommend that you talk to a landlord-tenant attorney. Oh, commercial time. This spring, starting on February 22nd, we have a new class at Mount San Antonio College called Landlord-Tenant Law. It will be taught by a landlord-tenant attorney, okay? All he does is practice landlord-tenant law. So if any of you are thinking about getting your broker's license at some point, and you want to really learn about landlord-tenant law, there's no better way to learn about landlord-tenant law than to take a class at Mount SAC. entitled Landlord-Tenant Law taught by a landlord-tenant attorney. And that's not me, because I'm not a landlord-tenant attorney, but he is a knowledgeable landlord-tenant attorney. So I throw that out at you. Also, I believe there is an exception where if you take a community college class, you can use that class for your continuing education. So you may be able to use that class for your 45 units of CE. Okay, is it true that a buyer can simply ignore any contingency, and by not signing off on that contingency, the buyer can simply walk? The answer is yes. If the buyer doesn't release their contingencies, then the buyer can still walk away, because the only way you can hold the buyer to the contract is after they release their contingencies. We're going to talk about that in paragraph 14. Okay, is a landlord-tenant clause pertinent to commercial and residential? He's going to be primarily residential, but he's a lawyer. He can talk about anything he wants to. So yes, the law applies to commercial, the law applies by residential. And if he doesn't know the answer, the nice thing is he can look it up and get back to you, because that's part of the class. Just like every now and then I get questions in my classes and I go, oh, I don't know the answer to that one. I can look it up and get back to you. So I think you'll enjoy the class. It won't be like the typical real estate classes you're used to, particularly if you're taking or you've taken correspondence courses. There's something really nice about taking a class from a professional, which is why at Mount SAC, I have a mortgage broker teaching finance and mortgage loan brokerage. I have an appraiser teaching appraisal. If you ever take me for legal aspects of real estate, as you know, I'm a lawyer. If you take landlord-tenant law, you're learning from a lawyer. So again, you learn from people who know their stuff. All right, so let's go on to the next page, and I will have time for questions afterwards. Page 5. So a carryover from paragraph 10, if your seller is selling a property in an HOA, homeowner association, they have 3 days to request the HOA documents. That's at the very top of page 5. So be aware of that. They have 3 days to request that. So again, you want to get those HOA documents as soon as you can. Paragraph 11, the property is being sold as is, but the seller still needs to disclose anything that could adversely affect the property. So the seller's not agreeing to do any repairs unless they agree to do them separately in this contract. This contract does not require the seller to do any repairs, but the seller is required to disclose any known material facts and defects. Paragraph 12, buyer also has an obligation to investigate the property. So we're letting the buyer know that they have an obligation to investigate the property. And during their investigation, inspection, or by their inspectors, if they damage the property, the buyer is responsible for making those repairs. That's under 12D. Paragraph 13 is title. Okay? How they take title. Tenants in common, joint tenancy, community property with right of survivorship. That's up to them. They need to talk to their accountant, their tax preparer, an attorney. Do not tell them how to take title. Do not tell them how you take title, okay? Because that would be the unlicensed practice of law. There are legal and tax consequences of how to hold title. So we're making that disclosure to them. Going to page 6. So here is the dreaded paragraph 14. So what I like to do with this paragraph is I'm just going to tell you what it says. I'm not going to read it to you. And after I tell you what it says, I'm going to then go into the chat and take your questions. And if you disagree with me, which is fine, it's probably because somebody told you something that was wrong, we can hash that out and I can go into the paragraph to show you where it says that. Unfortunately, and this is the real sad thing about real estate is this kind of regurgitation of stuff. We know it because somebody told us it, because somebody told them that, because somebody else told them that, right? Nobody ever looks at the agreement to see what the agreement actually says. It's kind of like the disclosure of a death. The law says that if the death occurred over 3 years ago, you cannot be sued for not disclosing. It doesn't say you have to disclose every death in the last 3 years, but everybody thinks it does. But that's not what the law says. So again, it can get kind of confusing because people tell you stuff that's wrong, and because oftentimes it's somebody who has a lot of experience, or maybe a manager or a broker, we believe them, right? So let me tell you what this paragraph does, and then we can discuss it and alleviate or explain any misunderstandings. Okay, so first of all, seller needs to make all their disclosures within 7 days. The TDS, the SBQ, or the ESD, or anything else. The lead-based paint, anything, if they have an old termite report, anything that could affect the value of the property, they have to disclose that in 7 days. I would add to that your AVID, your agent's visual inspection disclosure. You should disclose that in the first 7 days too, because the AVID is linked to the TDS in paragraph 3 and paragraph 4 on the 3rd page of the TDS. And since they're kind of connected that way, I think you need to give your AVID in the first 7 days as well. All right. Then from acceptance, the buyer has 17 days to inspect. So from acceptance, the seller has 7 days to disclose. From acceptance, the buyer has 17 days to inspect. We remember earlier, from acceptance, the buyer has 21 days to get their loan, and the buyer has 17 days for their appraisal. So you actually have 3 contingencies running. We have the loan contingency, we have the appraisal contingency, and here we have the investigation and inspection contingency. And that would include the buyer investigating and any inspectors the buyer wants to come out. That's all within the 17 days. Now, what would happen is if the seller gives a disclosure after the 7 days, well, then the buyer has an additional 5 days from that time period. Now, if they gave the additional inspection from the 10th day, it would only go out to the 15th day, so there's no change. But if they gave it on the 17th day, then the buyer would have 5 more days beyond the 17th day. Or if they gave it on the 15th day, it would extend the buyer's investigation for the 17th day to the 20th day. So again, we don't want sellers giving late disclosures, right? The seller needs to allow the buyer access to the property. And that access includes having utilities on, electric, gas, water, because you can't very well inspect if the systems aren't working. So those things need to be operational, okay? Now, on or before the 17th day, if the buyer finds things that they don't like, they can give a request for repairs to the seller. And the seller may ignore it. They may respond and say, I'll do it. They may respond and say, I'll do none of it. Or they may respond and say, I'll do some, but not others. Or they may respond and say, I'll give you money and I won't do it. We have a little negotiation there. But the reason the buyer has to give that during the 17 days is once the buyer releases their contingencies, now the buyer is committed to buy the property. So if the buyer gives their request for repairs on the 15th day and the seller doesn't respond, the buyer doesn't remove their contingencies. Now, the seller could, on the 17th day or 2 days early, because you can give the notice to perform 2 days early, the seller could give the buyer a notice to perform. If the buyer ignores that, then the seller could then cancel the deal. But most of the time, sellers don't want to cancel deals because they really want to sell their house. So the buyer and the seller will have a negotiation, so to speak, prior to the buyer releasing their contingencies. But going back to our earlier point, the buyer has 17 days to inspect. That contingency continues until either the buyer releases that contingency or seller gives a notice to perform. If the seller does not give a notice to perform, then the buyer's contingencies continue, which means the buyer can walk away at any time. If the seller gives the notice to perform, then if the buyer does not release their contingencies on or before the 17th day, the seller can cancel. But the seller doesn't have to cancel. But the seller can't cancel unless the seller first gives that notice to perform. So my recommendation is on around the 15th day, if you're representing the seller, you call up the other agent and say, hey, how's the buyer doing on their inspections? And they may say, oh, I don't know. I haven't heard from him. I haven't talked to him in a couple of weeks. Well, my seller wants to keep this thing moving, so they've gone ahead and asked me to give a notice to perform, because you can give the notice to perform 2 days early. That's the 15th day. And you may get the other agent saying, whoa, that's kind of rude, isn't it? No, it's not. You see, the buyer is supposed to remove their contingencies without being asked. So, but it's always a good idea to let the other agent know that it's coming, because you want to stay on good terms. Now, at the bottom, you'll see C, removal of contingencies with offer. That means there is no, or there are no contingencies, which means the buyer will buy the property regardless of whatever problems they discover. Now, you do need to list those contingencies or what the issues are in that contingency removal form. So you need to attach that. But this is risky for the buyer, and I don't recommend that because you really don't know what's going on in the house until you investigate the property. Then seller's right to cancel. Again, got to give the notice to buyer to perform. If you don't give the notice to buyer to perform, you cannot cancel, even if the buyer has gone to day 25 or day 30. You've got to give the notice to buyer to perform, okay? It is a 2-day notice, okay? If the buyer removes their contingencies, then they would be in breach of contract if they cannot perform. Likewise, the buyer doesn't remove their contingencies, they don't have to perform because they have a contingency. It allows them to escape liability. Now, let's say buyer releases their contingencies. Everything seems to be going good. We come up to close of escrow and buyer doesn't perform. And the seller says, oh, heck, we're going to cancel. Buyers missed the close of escrow deadline. Not so quick. Paragraph G says, if you've reached the end of escrow closing date, and the buyer's not performing, the seller needs to give the buyer a 3-day notice demand to close escrow. So that's the DCE form. That's separate and apart from the notice to perform. This is when you're at close of escrow, buyer is not performing. We need to give the buyer 3 more days to try to get their act together, okay? Effective cancellation on deposits, okay? Let's say you have not initialed the liquidated damages clause. If the buyer cancels, and it doesn't matter whether they've released their contingencies or not, the buyer gets their deposit back. The only way the seller can keep a deposit, buyer has released their contingencies and the liquidated damages clause has been initialed. If the liquidated damages clause has not been initialed and the buyer cancels after releasing their contingencies, the seller has to sue the buyer for breach. They can't keep the deposit unless the liquidated damages clause is initialed and the buyer has breached the agreement, which means they've released their contingencies and they are not performing. Right? And that takes us to page 7. So let's see what questions. There's nothing in the chat. I don't think I've ever made it through paragraph 14 with no questions. But that's good because it just gives us time for more questions at the end. And now we can really pick up speed because all the grueling stuff has been done. Paragraph 15, this is our final walkthrough. 5 days prior to close. Why? Because we want to make sure that tenant is out of the property, right? So if there is something going on in the property that was agreed to be repaired, or the property is not in the same condition as it was when the offer was accepted, this is buyer's opportunity to object to that. Right? Paragraph 16, if the sellers agreed to do repairs, they will provide paid invoices showing that the repairs were done. This assures the buyer that the repairs were done and paid for. So the buyer doesn't have to worry about a mechanic's lien because the contractor wasn't paid, right? Paragraph 17, prorations, property taxes and other items. So the easiest way to explain prorations is if you have a situation where, let's say I'm selling you an apartment building and escrow closes on the 15th of the month. Is it safe to say I've collected all the rents? Probably. I've collected all the rents because it's the 15th of the month. But since you're going to own the property for the second half of the month, you're entitled to half those rents. So what's going to happen is my sales price to you is going to be reduced by a half a month's rent. Otherwise, you'd be overpaying for the property because you're not getting the second half month's rent. So property taxes, of course, rents, insurance, interest, if you're taking over somebody's loan, these are subject to prorations. Paragraph 18 talks about broker compensation. Now, your broker compensation comes from a separate agreement. Typically, the listing agreement shared through the MLS because the MLS is an agreement between the two agents. Now, if you have a for sale by owner, there is no listing agreement. You want to make sure that before you present an offer on a for sale by owner, you get that for sale by owner to sign a single party compensation agreement. We call it the SP form. Sam Paul, the SP form. That creates a compensation between you and the seller, that for sale by owner, without establishing agency. Do not put your commission in this contract, this RPA. Because first of all, this contract is between the buyer and the seller. You're not a party to it. Second, the statute of frauds in California says that in order to have a valid compensation agreement in a residential transaction, you have to have a disclosure in 10-point bold type that commissions are negotiable, not set by law. That's not in this form. It's in the listing agreement. It's in the buyer representation agreement. It's in the single party compensation agreement, but it's not here. Putting your commission in this purchase agreement is not enforceable. So you don't do that, okay? Use that SP form. Paragraph 19, representative capacity. So this is really a DocuSign thing, okay? If you've got an entity like a trust, an LLC, or a corporation, you need at least 3 lines for the signature. You need the entity, you need the person who is signing on behalf of the entity, and you need the signature of the person. That's 3 lines. We don't have that many lines. So the representative capacity form will be added if you have an entity that is the seller or the buyer, all right? So a trust, corporation, LLC. If it's just individual parties, don't need it, all right? Paragraph 20 tells escrow what paragraphs escrow needs to be concerned with. And now we go to paragraph 8, okay? First line on C, broker's not a party to the escrow, okay? We are a third-party beneficiary, but we're not a party to this contract either. Okay, paragraph 21, remedies upon buyer's breach of contract. Paragraph 21A, okay, I don't know how to get rid of this thing. Okay, so whoever you are that put this on the screen, if you wouldn't mind taking it away, maybe I can do that by, there we go. I will get to that question in a minute. Hold on. Where am I? Okay. Paragraph 20. Well, actually, I probably have something in the chat. I should go into the chat. Okay. Nothing in the chat. Okay. Paragraph 21A basically says there is no such thing as a non-refundable deposit, okay? So please don't ever write non-refundable deposit, because the only thing worse than the unlicensed practice of law is the unlicensed practice of the wrong law. So California law is very clear in residential transactions. You cannot have a non-refundable deposit. So don't ever write that. And that's what paragraph 21A says. Paragraph 21B is the liquidated damages clause. So if both parties initial, remember, both parties have to initial. If one party initials and the other party doesn't, you don't have a contract, because you don't know whether the paragraph is included or not, because one party thinks it is and the other party doesn't. So either both parties initial or both parties don't initial. If one party initials and the other party doesn't initial, it needs to be countered out, okay? Same thing with the arbitration paragraph. Either both initial or neither initial. Please don't allow one party to initial and the other party not to, because you're not going to have a valid contract. Okay. Second, if both parties initial the liquidated damages clause, then the amount of the deposit, okay, can be kept by the seller if the buyer breaches. And the definition of the buyer breaching the contract is not performing after they released all their contingencies. So it's actually pretty simple. If the buyer hasn't released their contingencies and they cancel, they get their deposit back. If the buyer has released their contingencies and they cancel, they would lose their deposit if 21B is initialed by both parties. If 21B is not initialed by both parties, the buyer gets their deposit back. All right. Now, if the buyer intends to live in the property and the amount of the deposit is greater than 3% of the sales price. So if it's a $100,000 property. 3% of 100,000 is 3,000. If it's a $4,000 deposit, the seller would keep 3,000, which is 3%, and the buyer would get $1,000 back. That is not the same thing as liquidated damages are 3% of the purchase price. It cannot exceed 3% of the purchase price if the buyer is going to live in the property. So it's the amount of the deposit, but never to exceed 3% of the purchase price if the buyer is going to live in the property. If the buyer's not going to live in the property, then it's the entire deposit. That 3% cap does not apply. All right. So let me go to this question real quick. Does the buyer need to formally in writing cancel? As a practical matter, yes, because if you don't have formal cancellation by the buyer, you worry about the buyer trying to come back and perform when you go into escrow with another party. So yeah, you really do want the buyer to cancel. You want something in writing. Now, if you have a situation where the buyer's not canceling, but you want to get the property to get back on the market, what you can do is put the property back into the MLS. When you get the offer, either have the agent write in the offer or you put in a counter offer, something to the effect that this contract is subject to successful cancellation of the previous purchase agreement, and then refer to that earlier purchase agreement where you're trying to get that buyer to cancel. Then go into escrow with your second buyer, and then tell your seller to go out and hire an attorney, because that's as far as you can go. But at least you've now protected the rights of all the parties. Basically, you have a second sale contingent on successful cancellation of the first sale, but the parties are going to probably have to lawyer up because you got to get rid of that earlier transaction. Okay. Okay, moving on, and then I'll take the questions. Mediation. Mediation is simply the parties sitting down with a third-party mediator and try to compromise, try to settle their agreement. Mediation is mandatory unless it's excluded. For example, small claims cases are excluded, but mediation is required in pretty much all the other cases. Now, as I said before, mediation is mandatory. If you refuse to mediate, you're giving up your right to attorney's fees if you later win. All right. So again, it's very important to mediate. Anybody can serve as a mediator as long as it's agreeable to the buyer and the seller. So it can be their priest, their bartender, their masseuse. It doesn't matter. I will say that most mediators are attorneys simply because attorneys are familiar with the law and what a case is worth. But anybody can serve as a mediator. All of you people can serve as a mediator if you wanted to. And the buyer and seller wanted you to serve as a mediator. All right. 22B, arbitration. Now, arbitration has to be agreed to by both parties initially. They're at the bottom. And just like with the liquidated damages clause, if one party initials and the other party doesn't, you don't have a contract. So you have to counter that out. But you need to have agreement. Either you're arbitrating or you're not arbitrating. There are requirements of the arbitrator because the arbitrator is going to make a decision. By agreeing to arbitration, you are agreeing to give up your right to trial, and you're going to have an arbitrator who needs to either be an attorney or retired judge with at least 5 years of residential real estate law experience. That person will make the decision. You will not go into court. You see, with mediation, the mediator cannot make a decision. The mediator can only try to get the parties to settle, come up with a resolution. In both mediation and arbitration, you can be represented by attorneys. You don't have to be represented by an attorney. It's up to you, right? So before we go into paragraph or page 9, let me take out these 2 chats. Let's see. If the buyer would not remove contingencies in the time frame and would not perform, can the seller cancel the agreement? Is the buyer responsible for the damages? Well, if the buyer hasn't removed their contingencies, then there probably aren't going to be any damages from the seller standpoint, at least not that they can prove in court. But yes, the buyer can cancel during their contingency period, walk away. The seller has no right to sue the buyer for damages, has no right to keep the liquidated damages amount, because the buyer has the absolute right to cancel during their contingency period, and their contingency period continues until the buyer removes the contingencies in writing. All right. Okay. Let's see. Let's go into paragraph 9. All right, paragraph 23, selection of service providers like escrow, title, home warranty. That's the decision between the buyer and the seller. We do not guarantee their performance. Paragraph 24, we will report this sale to the MLS. Oh, for you agents representing the buyer, after escrow closes, always go into the MLS to see that you were reported on the buyer side. Unfortunately, there's some agents out there who have listings. They report themselves on both sides. Why do people do that? Well, not that you would ever leave your real estate company, but things happen. Your broker may close down, right? You may find yourself in a situation where you are looking to join a different company. That manager or broker will ask you, how many deals did you do last year? They already know. They've looked it up in the MLS. They just want to see if you're lying or not. So it's really important that you get credit for all of the deals that you do, because your commission schedule with that next broker will be determined on the amount of deals that you do. If you work for a team, your deals may be recorded under your team leader. What you might want to consider is making a copy of the closing statement from escrow on every deal you do. That way, if you do decide to interview with somebody, they ask you how many deals you've done, you can say, as you know, I was with the XYZ team. All of my transactions were reported under their license number or their MLS number, but here is a copies of the closing statements showing the deals that I did, and I did 8 transactions last year, or 12 transactions, or whatever it was, okay? Paragraph 25, attorney's fees, okay, to the winning party, provided they mediate their dispute before starting a lawsuit or arbitration. Paragraph 26 is the prohibition of assignment that I talked to you earlier. Now, it does say the seller will not unreasonably withhold their agreement to an assignment, but it does prohibit assignments without the seller's consent. Paragraph 27 is our commitment to fair housing. Paragraph 28 and 29 says this is the entire agreement. There are no other agreements. Time is of the essence. This is the entire contract, and there can be no changes unless signed by all parties. Paragraph 30 is our definitions. Note that it's not basically days, but days after or days prior, and we use calendar days. So tomorrow is day 1. So if you're doing signatures or getting agreements or whatever today, tomorrow is day 1. So it doesn't matter whether you get something at 8 o'clock in the morning or 5 o'clock tonight, tomorrow is always day 1. So you won't want to review those definitions. The offer is good for 3 days. That's in paragraph 31. You can shorten it or lengthen it. Then the buyer signs. At the top of the next page, page 10, is for the seller to accept. Or if they want to counter, they can check that box under 32 and attach a counter offer. They would still sign this agreement with the box checked because the counter offer states everything in the attached offer is agreed to, except for the changes specified in the counter offer. Last item I'd like to talk about just real briefly is the confirmation of acceptance. Not a required one, but it will be helpful for you. The way it works is I write an offer on your listing. Your seller accepts. Do we have an acceptance? No. You have to tell me that you've accepted. Okay? Or tell my buyer that you've accepted. All right? If we go back to the earlier paragraph under 31, where it says personally received by the buyer or by, this is where you write your individual name, not your company's name, but your name, so that you can then receive acceptances on behalf of your buyer. Now, you tell me that we have an acceptance, or you scan and email over to me that we have an acceptance. But how do you know I received it? Well, you would know if I received it if I or my buyer initialed here and then put in the date. Okay, January 19th, 2021 at 12:05 p.m. That means we've agreed that tomorrow, January 20th, is day one. Now, you don't have to use this paragraph, but if you do, you'll know when day one is. Well, let's say you don't use the paragraph. Can you do an email? Yeah. You email me and say, hey, Ed, did you get our confirmation? Did you get our acceptance? And I email back, yes, I did. Thank you. And then you email back. So tomorrow is day one. And I email back, yeah, so what? So what is that 15 days from now, when the contingencies are starting to expire, we know exactly when day 15 is because we know when day one is. If we don't agree, we'll all agree when day one is today. It's easy. It's 15 days from now. That's where it gets a little nasty, right? The next one I want to point out is at the bottom, presentation of offer and rejection of offer. Okay. This is where you can note that you presented the offer to your seller. Of course, whether you did or whether you didn't. But if your seller rejects an offer, I really encourage you having the seller initial at the bottom rejection of the offer and when it was done. That will do a couple of things. First of all, you've let the other agent know that it was presented to your seller and they rejected it. But equally important, the other agent won't think that maybe you didn't present their offer. And unfortunately, we have heard stories about agents not presenting offers. This is particularly important if you're in a multiple offer situation. And I know we have a few of those out there. If I'm a listing agent and I'm in a multiple offer situation, the first thing I do is I contact the other agents. I let them know that we're in a multiple offer situation in case their buyer wants to strengthen their offer. It's a nice way of saying, if your buyer wants to write another offer at a higher price, we'll wait for it. Second thing I'll do is I will offer each of them an opportunity to present their offer to my seller and myself this evening or tomorrow afternoon or whenever. And I will give them staggered times, 5 o'clock, 5:45, 6:30, and they can come in and present their offer. Now, my seller doesn't accept their offer. Yeah, they're going to be a little upset. but they're not upset at me because I gave them every opportunity to get their offer accepted. And they couldn't sell the seller on their offer. It's not my fault. And the reason that's important is that 2 months from now, I may be writing an offer on one of their listings. And I want them to know that I'm a good agent and I did not cheat them out of a commission. All right. So again, the better your relationship is with the other agent, the better your transactions are going to be. All right. So we have something in the chat here. Is there a CAR webinar tomorrow on the RPA? Should I take it just after taking yours? Are they going to be? Oh, there is a CAR. Hopefully we're in agreement. If you have a chance to take Gov Hutchinson for an RPA class, even I would sit through an RPA class with Gov Hutchinson. I have sat through RPA classes with Gov Hutchinson because I think Gov is probably the best in the best. I mean, he's really good. The other ones, I don't know. If you want to take it, if it's free, do it. It says there's not, because there is a cost to it. If they're going to charge you, I think you've got everything you need to know. In addition to teaching at Mount SAC, I am a GRI instructor. So I do teach the GRI class on the purchase agreement when Gov can't. I'm his backup. I think I've gone through the contract as well as I can, as well as anybody can. I think I can hold my own against any CAR attorney. But Gov is the best. Would I pay for Gov? No. I think I'm pretty good. But Gov is really good. If it's free, take Gov. If he's going to charge you a lot, I don't think you need it. Like I said, this meeting has been recorded. There's probably 3 or 4 of these webinars also recorded. So if I missed anything, you'll catch it on the other. The other thing I'd like to point out, and that's really down here, this is not legal or tax advice. This is just an educational experience. But my job, or the reason I do these seminars, is to let you all know that Mount SAC has a real estate program. And while you don't need a real estate license, you have one. You know people that are thinking of coming into the business. They're going to learn more taking real estate principles from me, okay, than they are in a home study course. If any of you are thinking about getting your brokers and you want to kind of learn more because that home study course you took to get your real estate sales license, you can take real estate principles from me if you haven't taken it before at Mount SAC, because it's the same questions on the sales exam and on the broker's exam. It's the same questions. So, that's why I do this, to promote the real estate program at Mount SAC. And I'm always happy to talk real estate with everybody. So if you have a question of a form, or what does a form do, or what form should you be using, you can contact the CAR hotline. But if you want to just chat, I'm happy to do that. It's just I can't give you legal advice. And I'm going to know if you're asking legal advice. But if you want to just chat about a form or chat about something in real estate, I love to talk about real estate. I mean, that's kind of what I do. All right, so let me go into my chat, and I can't find my chat. Where's my chat? There it is. Hold on. Thank you. Great. I'm glad everybody had a good time. Let Laura know you like me. She'll schedule me more. I also do seminars other places. I always try to put my seminars on my LinkedIn page. So contact me through LinkedIn and you'll see where I'm doing other seminars when I do this seminar. So I'm always happy to talk to you. I've got another chat. Where is it? let's see, what does it say? Thank you. Okay, great. So I think Laura's actually left us. She had another meeting to go to. So this will be it. She will be posting this in about 24 to 48 hours on the Tri-County's website, so you can watch it there. And don't call me. That's the other thing I wanted to say. Even though my phone number is here, don't call me because we're not on campus. We're all online, but I've got online classes, so I check my email all the time. Thank you very much. Enjoyed chatting with you. Hope you learned a lot, and we'll let you know when I'm doing the next seminar for Tri-Counties. And between then and now, reach out to me at LinkedIn. I don't do Facebook because there's all that social drama in Facebook. Yeah. But at least LinkedIn is a little bit more professional. But I always post my classes that I'm going to be teaching or whatever in LinkedIn, so you can catch me there too. Thank you. Bye-bye.